Possibly, yes. In a spousal support case, North Carolina law lets the judge order the supporting spouse to pay the dependent spouse's reasonable attorney's fees. If you're a dependent spouse entitled to alimony or post-separation support and you can't realistically fund the litigation yourself, the court can shift that cost to your ex. Here's who qualifies, how to ask, and the limits nobody should learn about after they've hired a lawyer. Fairness, the practical kind. Alimony cases are, by definition, fights between a spouse with money and a spouse without it. If each side had to fund their own lawyer no matter what, a supporting spouse could win simply by outspending the other, dragging the case out until the dependent spouse ran dry and took a bad deal. The fee statute exists to keep the fight from being decided by the size of the war chests instead of the merits. It puts both spouses on something closer to equal footing. The statute keys off the same framework that governs support itself. The court may award reasonable counsel fees when a dependent spouse would be entitled to alimony or to post-separation support. In practice, that means showing three things. 1. You are the dependent spouse, actually and substantially dependent on your ex for support or substantially in need of it. That's the same threshold that governs the support claim itself. 2. You're entitled to alimony or post-separation support. The underlying support claim is a winner, not just a filing. 3. You lack sufficient means to pay for the litigation yourself. You don't have to be destitute. The question is whether paying your own fees would eat into the resources you actually live on. Notice who that leaves out. A supporting spouse cannot get fees under this statute, and neither can a dependent spouse whose support claim fails. The fee award rides on the back of a successful support claim. It isn't a freestanding prize. This is where the fee statute and the fault rules collide. A dependent spouse who committed uncondoned illicit sexual behavior before separation is barred from alimony. And a spouse who isn't entitled to alimony isn't entitled to alimony-based attorney's fees either. For post-separation support, the picture is softer. Their misconduct is a discretionary consideration rather than an automatic bar, so an award and fees with it may still be possible. If fault is in your case's bloodstream, understand how it affects support before you count on a fee award. The two rise and fall together. You ask the court by including a fee request in your pleadings or by motion as part of your alimony or post-separation support claim. 2 timing points are worth knowing. You don't have to wait until the end. Fees can be requested alongside post-separation support early in the case, precisely because that's when a dependent spouse is most likely to be squeezed. An early fee award is often what makes it possible to keep competent counsel all the way through trial. And don't leave it out of the pleadings. The cleanest practice is to plead the fee claim from the start, so it's preserved no matter how the case unfolds. Reasonable fees, which is a real limit, not a formality. The judge looks at the nature and scope of the legal services, the skill and the time the case genuinely required, and your lawyer's rate compared to what other local attorneys customarily charge. The award covers work on the support claim. It is not a blank check for every claim in your divorce. The court can order payment as a lump sum or over time, secured the same way alimony is. And here's a candid word from this side of the desk. Do not hire the most expensive lawyer you can find on the assumption your ex will foot the bill. Fee awards are discretionary, they're measured by reasonableness, and they can come in below what you've actually spent. Hire the lawyer whose fees you could survive paying yourself and treat a fee award as relief, not as a plan. Different statute, different test, and this trips people up constantly. Fees in custody and child support cases run under their own statute, which asks whether you're an interested party acting in good faith with insufficient means. No dependent spouse requirement at all, plus an extra finding in support-only cases. Many family cases bundle both kinds of claims, which is exactly why your attorney should keep time records that separate the work. Each fee award has to stand on its own statute. If you're the dependent spouse staring at a legal fight you can't afford, don't assume you have to take whatever's offered. Fee shifting exists for exactly your situation. At McCrary Pack, we help spouses across Iredell, Catawba, Alexander, Caldwell, and Burke counties build the support claim and the fee claim together from the first filing. The full article is linked below. Call us before money pressure makes your decisions for you.